I need to know everything, who and the what and the where, I need everything. Trust me, I hear what you're saying, but act like it's new what you're telling me. I'm curious, George, I hop in the Porsche, 5 on a horse, I'm ready for war, I'm coming for throats, to turn to a ghost, I need to know everything. Now you'd be surprised at the info you get is by letting them talk, so I'm letting them talk. Gotta keep quiet, maneuver in silence to let them in, talk up their body, another one body, that's just how it go. I got some secrets, I'm shaking the game so they stay on their toes. Stay in your lane, I stay on the go. I get to play with the pros and that.
Welcome to Startup on the Blocks, everyone. Hello, Daniel, how are you?
Good, how are you?
Fantastic. I'm going to pull up my PowerPoint in a second and go over a few items, and then we'll get started chatting with you. So let me get it running here. Yeah, clicking all these buttons is challenging sometimes. Yes. All righty. Yes, so I wanted to, for the new people, I wanted to kind of give you a feel for what Startup on the Blocks is all about. We do this event every Thursday night from 6. We do networking, and then at 7 we do our best practice presentations. And tonight we got Daniel on, and so. But I definitely want to thank our sponsors here. Industry has been supporting us with our pitch competition, and also next pitch competition is going to be supported by the First, and we partner with the Gulf Coast Minority Chamber and the Bantucola Chamber, and Gulf Powers came on as our founding sponsors, and the Small Business Development Center is also one of our partners. And tonight, like I said, we have Daniel Fraley, and he brings some real, great perspectives, being a patent lawyer and also a startup founder. I'm looking forward to learning more about his startup, and hopefully he'll give us some pointers on patent stuff. Next week, we'll have 2 founders on. Frank Goodman, he's out of the DC area, and he's building an application called Bill, and I'm looking forward to hearing some more about that. And our own Kyles, we'll have him on as well, and he'll be talking about his startup that he's working on here locally. And on the 21st, we got Dr. Nashley Cephas, and she's got a really interesting story. And for those of you I hadn't heard about her story, a part of her story is she got a PhD in AI from Georgia Tech, but there was another lady in Georgia Tech, Jewel, I think her last name's Burks. She was working at a call center, and a lot of people were calling in for repair parts for their appliances, and they kept calling in. They said, "Well, I got the picture, but I don't know where to get the part from." And so Joel got the idea that, just like Shazam, if you play a little tune and then it tells you what the song is, well, she said, well, if we could do the same thing with pictures, and so she started a company called Part Pick, but she was a non-technical founder, and she got lucky. Dr. Cephas was just graduating, and they partnered up, and their company PartPick was purchased by Amazon. So, so they had a really great success story. And Daniel, you, I think this is your first time using this Hopin platform, right?
Yes, it is.
Yeah,
working
yeah.
through the bugs.
Yeah, and so that's another interesting startup story. They launched in February 2020, and I found out about them in March 2020, and they just raised like $7 million, and then by June they raised another $40 million. And then by November they raised $400 million, and then earlier this year they raised another $400 million. They're worth over close to $7 or $8 billion now. That's a startup for you, isn't it? Yeah. So but yeah, that's some neat little startup stories. So Daniel, go ahead and introduce yourself and give us a little idea about your background.
So my name is Daniel Fraley, and I actually grew up in Ohio. That's where I'm originally from. And I went to engineering school in Ohio, in Cleveland, Ohio, actually, at Case Western Reserve, and got my mechanical engineering degree, and worked as a mechanical engineer for a while, worked in a steel mill around big, heavy machines. It was a real cool, fun environment, very dangerous. And then I went from there down to Dallas, where I went to law school at Southern Methodist University with the goal of becoming a patent attorney. I was in Dallas for about 5 years, then went to Austin for about another 5 years. And then I just found myself moving to Pensacola to kind of work for myself, kind of do my own thing. Yeah. So, fantastic. I've worked a couple of different places where I've been an engineer. I've worked 3 different law firms doing patent work. I've, and I even went through the G Alpha program here in Pensacola, which is a Studer, thing.
Spring, yeah.
No, I'm sorry. It's with the Spring. I'm sorry. Yeah. With the Spring, it's a company or a generator, the platform out of Milwaukee, Wisconsin, and they do startup stuff. And I think the guy you have speaking next week, he was actually in my group there in the G Alpha group.
Oh, the G Alpha group. So I didn't know you participated in the G Alpha program. Okay.
Yeah, so I did that, and it was very interesting. So I have a lot of technical skills in terms of engineering and the legal stuff in terms of patents and trying to figure out what that is for a startup. But in terms of things like market research and pitching ideas and funding and that sort of stuff, that stuff I kind of lacked in. So I went through that process. At the moment, I'm actually kind of bouncing around a few different ideas of startup projects that I'd like to work on. A couple of different physical products.
Yes.
And inventions and at the same time, I also do some patent work on the side. So, but I don't have a 40-hour a week patent gig. So I'm able to kind of split my time up depending on how things go. So,
how did you get connected in this startup ecosystem here?
It was one of my goals. I mean, I wanted to get involved with the startup ecosystem. I knew that I had a lot to offer in terms of knowledge and skills. And I also knew that, there was a lot of stuff that I kind of wanted to know too. So I just kind of wanted to just jump in, get involved, meet people, talk, do things. And, maybe I meet somebody who would be a great fit for something that I'm working on, or maybe I think I'd be a great fit for somebody else. You don't know.
Yes.
That's why these sorts of events are great, because you never know who you're going to run into, who you're going to meet. I went through the G Alpha program, and I've made a good friend out of that program with someone through that. And we stay in touch and, kind of help support each other.
Yeah, and that's really important. Meeting other entrepreneurs that are working and connecting and supporting each other, holding each other accountable. I think that's a really it's no fun working by yourself. At least not for me. It is. It definitely isn't. So yeah. Uh, so what's your so you said you met somebody in the GF program, so that was good. And so how do you feel with going forward with your startup idea, after doing the G Alpha program?
It gave me a lot more confidence.
Okay.
And a lot more, it kind of got me going down that path a little bit more. I think about it more. I think, this is actually possible. There were some tools and some things that I learned in that class, which is it's open to everybody as far as I know. I mean, it's very easy to apply and get in. So I recommend that if somebody's interested, they do that. And it really helped out. Like I said, I had some skills, but there's always those question marks. I think that's one of the big things that really stops us from taking action on our ideas and on our goals, is that there's that question mark that's out there. It's like, I don't know how to do this thing.
Yes.
I don't know what to do. It's funny because when you think about some very complex things that you know how to do, you don't even, you just go, oh, that's easy.
That's what
you don't even think about it, but to somebody who's never done something before, it can feel very intimidating. And once you get familiar with certain things, you go, oh, wow, that's easy. Why did I hold back all this time?
Right. Yeah. So like what I learned, in the startup ecosystem stuff, and I saw what was going on here. I've been doing entrepreneur stuff pretty much all my life, but in the startup world, like my startup Cognitive, getting the ecosystem, I wasn't really familiar with the ecosystem, and so but as I started learning about it and then started doing a little traveling, like for example up in St. Louis, their ecosystem, there's this organization called I-10, and what they do is they get you at the beginning of your idea stage, like that G Alpha thing, and but they have a 12-week program that they teach you the lean startup methodology. As a matter of fact, they use the lean stack application for that, and so you go through that, and then they call it validation modules. And so what they're doing is they're validating that you kind of understand the lean startup methodology, and how to take your idea and validate it, et cetera. And the purpose for that is then they can actually refer you to the accelerator programs that give you funding. They can refer you to the pitch competitions that give you funding. By just saying you went through that program, you kind of validated. They can, it takes a lot of the risk out of your application. So we didn't actually have anything like that here. And so when we did startup on the blocks, since we don't have our own training program like that, we just refer people to the startup school, because it basically kind of it kind of answers most of your questions. But this year we're gonna get that the system from Lean Stack, and that way we can run the people through there, and we can kind of validate that they went through the process, and because what we also do, we refer them to all these different opportunities that are out there that you can apply for. But if you don't know how startups work, when you try to fill out an application, it's not going to make sense to you. But once you go through these programs, and whenever there's an application to fill out for a pitch competition that may be $20,000, $25,000, $100,000, or a training program or whatever, then you know how to pitch your idea in writing, how to pitch it verbally, and that's kind of so that's why we started on the blocks, just to kind of make sure people learn the best practices for building a startup. And our events are open to everybody that we do here every Thursday, and I think we've done close to 60 events. Yeah, and Yes. So what are you? You have a presentation. What are you what do you got in store for the audience tonight?
Yeah, I have some slides that I just kind of threw together
Okay.
last minute. I was working on putting together a big presentation that's was kind of a two-part presentation
Mm-hmm.
that focuses on taking an idea and turning it into a product, and then
Yes.
kind of the intellectual property aspect of it. Depending on how much time we have, I mean, I could just jump straight to the kind of to the intellectual property stuff.
Yeah, yeah. So like, yeah, we got plenty of time, and so folks in the audience, you can actually put your questions in the chat, and the folks out on Facebook, you can post your questions in the comments. And so we typically end at 8, but we can go to like as late as 8:15. And the main thing is get the information out there to everyone, and um, you know. And just help people understand, from your knowledge. And I will tell everyone that a mechanical engineer is a special type of engineer. So, they tend to be pretty versatile. And so they, so I think you have a lot of expertise that actually would be very useful. All right, go right ahead and let's see if you can get your presentation up. And then once you get that, I'll get off camera here. But I'll be listening in and be letting you know if there's any questions or anything.
Okay.
It's good. All righty. Go right ahead.
Think that works. All right. So this presentation, like I said, it was kind of encompass the whole process of from conceiving of an idea all the way to having a product on the store shelf, which is actually a process that I had done in a previous occupation that I worked at. So when I was working as an engineer, I went through that whole process with them, with a few different products, and it was pretty cool to see. But like I said, for this meeting here, we're going to skip through the product stuff, and we'll just go straight to the intellectual property. I'll talk about all intellectual property kind of as an overview, and then more specifically about patent stuff, because people have a lot of questions about patent things. But when we get down to the end and you guys have any questions, feel free to ask me about anything intellectual property related, patents, trademarks, copyrights, that sort of thing. And I'm happy to answer any of those questions. So before we get started any further, I had to do a quick disclaimer. I'm not your attorney. This is not legal advice, all that standard stuff. The information that's in here is just to help you facilitate, your own interaction with an attorney. So if you feel like you need legal advice on something, go please seek an attorney. And this doesn't just apply to patents. This is everywhere. I think it's important to, not cut corners when, on certain things, when the stakes can be, pretty high. So I'm going to go ahead and jump into the intellectual property section here. Now, intellectual property, in terms of when you want to, start thinking about intellectual property, protecting your intellectual property, especially for patents, you want to get on that as early as possible. So it doesn't hurt, if you've got an idea, if you think you're going to turn it into a business, it doesn't hurt to reach out to a patent attorney, talk to them, see what they think about your idea. Is it something that's even patentable? That sort of thing. There's, I'm sure there's plenty of questions that you may have that you want answered. So, let's see here. So in terms of intellectual property, there's many different types. A lot of times people think of things like patents. There's also trademarks, copyrights, trade secrets, trade dress, and there may be some other ones. So a patent is something that protects an idea. You're going to protect, a new type of highlighter right here. I got this highlighter. It's pretty cool. It's got a little click on, click off, and it's got a little door that closes when you click it off so that the ink doesn't dry out. You don't need a cap for it. This would be the type of thing that you would patent if you came up with an idea for this. There are other types of patents. You can patent things like genetically modified plants. You can patent designs on stuff like, Chevrolet will have a design patent for the specific look of their cars. So things like that can help them protect against other companies trying to rip off their design. And then trademarks, most people are kind of familiar with trademarks. They are, your Nike, McDonald's, your Walmart, and it can protect the word itself. You can also protect slogans like "Just Do It" for Nike. You can protect the swoosh. So there's a lot that you can protect with trademarks. Trademarks will last forever as long as you keep renewing them, and they can be a pretty powerful way. But they're not to protect ideas. They're protecting the source of those goods. They're protecting the identifier. The trademark is an identifier of a source of goods. When you buy a Nike shoe, the trademark that's on there should tell you that the Nike company built that shoe, and you can be assured that that shoe is quality because it says Nike on it, and that the Nike company makes good stuff. Copyright is a type of intellectual property that actually protects artistic works, artistic expressions. So paintings, sculptures, writings, pretty much anything that's written, created, things like that. Now, copyright is not going to protect the things that are protected by these other aspects of intellectual property, but the copyright protects like if you write a book, if you write a blog post, if you, like I said, sculpture, that sort of thing, those copyrights will last. It usually is measured by the life of the author plus so many years after they die. Or if we're in the case of a corporation, it's a specific number of years. In fact, I think the original Steamboat Willie cartoon, the Disney, the predecessor of Mickey Mouse, that is actually coming up on its expiration in a couple years. And it's going to be kind of interesting to see what happens, because once that copyright expires, then there's going to be no restriction on anybody being able to use that image of that Steamboat Willie, which looks a lot like Mickey Mouse. So he's got a couple of differences to the actual Mickey Mouse, but there's that. And then, of course, several years down the road, Mickey Mouse himself, that will actually expire, and that will be open. Trade secrets. So trade secret would be something like maybe a list of customers. It could be a specific way that you build a machine, a specific like type of fixture that you use when you're welding the pieces of a machine together. There's a lot of different things that in trade secrets. Probably the biggest one that everybody knows is like the Coca-Cola formula. They keep it under lock and key. That's a trade secret. And part of the key, if you will, to the trade secret is that it has to remain secret. If the secret gets out, that's it. There's no more trade secret. So companies do a lot to protect those secrets. And as long as you keep those protected, those will last forever. So there can actually be a little bit of interplay between the patents and the trade secrets. Maybe, if you want to keep something for longer, you may choose to keep something as a trade secret as opposed to patenting it. So there's definitely uses for trade secrets. What would you do with a trade secret if it, why is it valuable? Well, if somebody at your company, takes the Coca-Cola formula and they run off, then you can sue them. You can sue them for that breach. And so, that's the purpose of having that trade secret protection, is that you'd be able to go after somebody or a company that stole your secret. It took it and ran away with it. And then trade dress is something that's similar to kind of a trademark, but it protects kind of an appearance for something. So a good example would be the way a specific restaurant looks. If there's like if you see the Whataburger, those restaurants, a lot of them have that A-frame style building. It's orange and white. Whataburger when you see one. You don't need to see the logo or anything like that to know that that's a Whataburger. And a lot of other things too, like even the shape of the Coca-Cola bottle. Going back to Coca-Cola, that's a trade dress, because if you see that bottle from a distance, even if you can't read what it says Coca-Cola on it, you're going to look at that and say, that's a Coca-Cola bottle. That's an example of a trade dress, and that's a type of intellectual property that can be protectable as well. So now we're going to just focus on patents from here on out. Like I said, I'm happy to answer questions about other stuff if anybody has them later on. But in terms of patents, so what is a patent? Well, a patent is a limited monopoly granted by the government to the inventor or the company that owns it in exchange for you publicly disclosing your invention. So this is an exchange. So the patent is a public document. When you file a patent and it gets approved, that's now a public document, and anybody can see it, anybody can read it and know how to make and use your invention. In exchange for that publication of how you do your invention, the government will grant you this limited monopoly. In general, it's about 20 years. So you've got a little bit of time to recoup the cost of inventing this. That brings us into this next point. So, what's the whole purpose? You're fostering innovation by protecting the efforts. A great example of this is drug companies. So if, imagine these drug companies, they can cost hundreds of millions, even billions of dollars to develop a drug. Imagine how many, different formulas they have to go through and test again and again and again, and all the regulatory hurdles that they have to go through before they actually get approval to put these drugs on the market. It can cost them, like I said, hundreds of millions, even billions of dollars to get a drug out there. But the drug itself may actually not cost a whole lot to manufacture. So in order to protect that investment of the drug company, they get this limited monopoly through the use of the patent system. And that allows them to charge a higher price for that drug, that brand name drug, for that 20 years or whatever the period may be. And then they can use that higher price to help pay back what they spent developing the drug. You could easily see how if a drug company came up with this formula and spent billions of dollars, and then all of a sudden another company came along and just looked at the formula and said, oh, this is great. We can make this for pennies on the dollar and sell this and make money. Well, then pretty soon the companies would be bankrupt. There'd be no incentive for them to spend all that money to keep creating. So that's kind of the whole point of the patent system, is this: you're granting this limited monopoly, and with this limited monopoly, you're going to be able to charge a little bit higher prices for it, really whatever you want, because you're the only one that can sell it. And then you'll be able to recoup the costs. So in that sense, because it's that government monopoly, the patents have that value for that 20 years to the owner of the patent. That patent, can then be, you can make the product yourself, you can sell the patent, you can license the patent, you can do a lot with it. It's a property right. And just like any other property that you own, you can do a lot of things with it in order to, make money from it. So, what can be patented, right? A lot of people coming to me all the time saying, hey man, I got this great idea for this thing, I'm going to get a patent on it. You can't really patent that. So, what can be patented then? Well, there's a great quote that says, anything under the sun made by man or woman these days in this case. But this doesn't mean everything is patentable. There's a couple qualifications, anything under the sun made by man. So one of the keys to the patent process is that it's something that has to be made. So things that can't be patented would be like laws of nature. You wouldn't be able to patent E = mc². it's great that Einstein came up with it, but he can't patent it. He could patent, something that he used that formula to help build. For example, I had a patent case that I worked on where they used a formula to calculate something in as part of a process of certifying things, and that formula went in as part of the patent process, and that was something that could be patented then. But that was because it was part of how that specific method was performed. It was a way that they were calculating these things. Other things that can be patented, like physical phenomena, like you can't just go out into the woods and find a great new plant and say like, oh, I'm going to patent this plant. Now you can patent a genetically modified plant. So if you take and like the Monsanto and all these other big companies, if they take and genetically modify the plant or animal even, they could take that and then get a patent on that. Like there's a lot of research and stuff about engineering bacteria to digest certain things, oil and the spilled oil and microplastics and things like that. So there's a lot of interest in that sort of thing. So those sorts of things could be patented, but not just something you find that exists in nature. Can't patent abstract ideas. So if you have a method for calculating tip that in your head, that's not patentable because you can't really enforce it. If you're just doing something in your head, well, how do you prove somebody was doing that? How do you sue them for it? Nuclear weapons, purely for security, national security interests, and then things that aren't useful or they violate known physical laws. Like it's pretty well established that perpetual motion machines, don't exist. And so if you try to take a perpetual motion machine patent to the patent office, they're going to say, get out of here. But that still leaves a lot of stuff that's out there. I mean, there's, so aside from those things that there's good reasons why they shouldn't be patented or can't be patented, in general, you're open to a lot of stuff. And that could be, like I said, plants, genetically modified plants and animals, machines, compounds, like you can drugs, methods for doing things. There's covered business method patents. Those are a bit of a controversy right now, but there's patents for a method of doing business, in fact. So there's a lot of stuff out there that can be covered under patents. Most people, when they think of a patent, they're thinking of a utility patent, and a utility patent is covering a functional thing. Like I said before, it could be a method, like a method of refining oil into gasoline. That could be something that's patentable, or it could be this highlighter, this new type of highlighter with this cool click thing, and it doesn't dry out because it's got the little cap on it. But there's also design patents, and the design patent protects the ornamental appearance of a device. So sometimes if you're looking at a device or something that you see and you look at it and it says little patent number on it and it says got a D in front of it, that would be a design patent. And so they're protecting that ornamental appearance of that product, not necessarily how it functions. You see that a lot in things like like maybe this water bottle, or some little kitchen gadget. A lot of times I get a lot of calls from clients and they'll ask me a few different questions. One of the questions they want to know is, how long does it take to get a patent? They want to know, I'm paying you all this money. When am I going to get something out of this? So that's really a difficult question to answer for a variety of reasons. A good guess would be, at least 1 to 3 years is what you're going to expect. I would be very shocked to get a patent approved within a year of filing it. Now, there are certain instances where you can have the patent process accelerated and it's supposed to finish within about a year, but that's not, there's certain requirements to meet to get that. I've seen patents take, I've seen people continue to file patents and work on patents 5-10 years. Depends on how valuable the technology is. It may be worth continuing to pursue if it's that valuable. The other question I get a lot is, how much is it going to cost? Attorneys are expensive. All this stuff is just, people just think like, man, dollar signs, dollar signs, dollar signs. How much is this going to cost? Again, that's another difficult question to answer, but every law firm is going to charge different amounts. They're going to do things differently. There's definitely different qualities of a patent application that can be written. The way the patent usually works is you file your application with the patent office, and they will send you, a communication back saying, we're not going to approve your patent application because of, and then they're going to list all these reasons, which are usually other inventions, documents and stuff out there that the person at the patent office thinks already talks about your inventions. You're as a patent, it's got to be something that's new. So they want that. It's got to be new. And not obvious. So how many responses it may take before you get to the point where they approve it, that's a difficult thing to answer up front, because there's so many variables that can happen. I've seen patent applications that get approved and right away, and I've seen ones, like I said, that 5-10 years down the road, you're still trying to get the patent allowed. That's for big patents. I mean, there's probably $100,000 patents out there. I mean, easily. That's not the norm, but it's definitely possible, depending on how much it costs, how much time you spend on it, how lengthy the disclosure is. Some of these, I worked on a patent for Fitbit, the wearable watch Fitbit, and this application was like a book. I mean, it was like 100 pages long, and I just cringed to think about how much they had to pay for that patent application. But for something that's more on the simple end, like, again, going back to this highlighter, something like this would fall on that lower end. This is a pretty simple device, and if you weren't trying to patent 1,000 different variations of it and different mechanisms, you would probably be in that, easily in that $5,000 to $10,000 range by the time it was all said and done. Again, that's going to vary a lot person to person, and there's all sorts of stuff. Sometimes the examiners of the patent office are stubborn. Sometimes they don't understand English very well. It's frustrating, I know. And, so there's just, it's a really difficult question to answer. When you're working with your attorney, they can definitely, work with you, and you can, talk with them and just say, hey, look, I don't want to pursue this anymore. I'm done. Like this, I've thrown enough money at this. I've had enough. Or you can, you could say, you know what, I'd rather finish this sooner rather than later. I don't care if I have to, sacrifice a little bit of quality on my patent. I really just want to get the word patent stamped on my product. So like, let's just, cut down the back and forth, and let's just kind of accelerate this to the finish line. So that's something that can happen as well. Another question. Ooh, can you write your own patent? Yes, technically. So under the laws in the United States, you're perfectly allowed to write your own patent application as the inventor, and you can file it at the patent office and work with them and get a patent. But I would say that that's extremely risky. There's a reason why patent lawyers have, 7 years of college before they're, even considered patent lawyers. There's so many tests, there's so much learning and studying and stuff involved. Asking if you can write your own patent is like asking if you can perform your own knee surgery. Well, yeah, you probably can, but if you don't know what you're doing, you might not like the outcome. So, if you don't have any money and there's absolutely no, there's nothing you can do, maybe that's, maybe that's a better route than nothing. But that would be something that would be, I would highly discourage it. And not just because I'm an attorney, but because I know, when I see other people write stuff, I see all the mistakes that they make, but they don't know they're making. They they don't know what they don't know. And that's where you become really dangerous, is when when you don't know what you don't know and you proceed to do something like that anyway. I don't think there'd be any serious risk to your legally or whatever to yourself. I just think that the patent itself would probably just be garbage. That'd be the outcome, would be that it would just be worthless. And you could have spent the time and money, paying somebody else a few $1,000s to get something that actually wasn't worthless. And that's probably a better use of your time, especially as you're trying to, start up a company. And kind of stepping back a little bit broader, do you need a patent? Well, no. I mean, a lot of times people will get pretty discouraged when they come to me and they say, hey, I want to do a search to see what's out there and see if you think I can get a patent on my invention. So most patent law firms, myself included, will do what's called a patentability search. You just call up a patent attorney, your law firm, and just say, hey, I've got an idea and I want to do a patentability search, or a prior art search, sometimes it's called. I want to just see what you think the chances of me getting a patent on my idea is. So when that search comes back and it's not good, it can be discouraging. But you have to know that, patent's not required to make a successful product or a successful business. And patents, again, are only a limited monopoly. So after time, they do expire. I mean, this right here on the screen is the original patent for what we call Velcro. This was the original hook and loop fastener patent. And you can see the hooks here and then the loops down here, and that's Velcro. And in fact, I don't think Velcro was actually very much of a commercial success until the patent expired. I have to read a little bit more as to why, but the point is that the Velcro company still exists. They're multi-billion-dollar company. They have no problem selling Velcro to people, even though you can buy no-name brand stuff at the store all day long for a fraction of the price. So there's a lot of other things you can do besides having a patent that can make your business stand out. You can be first to market. You can have the best product. You can have the best marketing, the best name, whatever it is. Look at the Yeti cooler revolution. Yeti came out with these coolers, and oh my gosh, these things are so expensive. Who would ever buy that? Yada yada yada. And then next thing you know, boom, boom, boom. Everywhere you turn, everybody's making these expensive high-end coolers that are competing with Yeti. Those other companies probably don't have patents on those inventions, and I assume they're not infringing Yeti's patent. So there's a perfect example of those products can be very valuable even though they may not be patent protected. That's kind of all I have here. I wanted to just kind of end with that little bit of info. There's my information in case you want to do some, want to see my website and get in contact with me or whatever. I'm not here to plug myself. This isn't about me, trying to drum up business for myself. It's not why I'm here. But just in case anybody wants to contact me and has any further questions, that's kind of my info. And at this point, I'm happy to kind of answer any questions from anybody.
Great, Daniel. And so having a patent attorney in our local ecosystem here, I think that's pretty fantastic. And I think you are a great asset to the community here. And so there's no harm in plugging yourself. We have guests on all the time because they provide services that the founders actually can use. So don't ever worry about apologizing for anything like that. So we got a couple of questions in the chat here. Versal Vance, he's tried the patent summit. He paid $10,000. And after 2.5 years, it didn't get approved. But the idea was related to banking and financial. And so he's basically said his attorney insisted that it needed to be a software patent. And he said we ran into many conflicts with existing software patents. His question is, can a banking or financial idea fit into any other category rather than a software patent?
I mean, without seeing the technology and looking at it, it'd be really hard for me to just answer that question. But there's probably a couple different ways that things could be patented. When it comes to software stuff, there's a little bit more play than you would have with, like a mechanical device. I know that in terms of software, there was a big wrench that got thrown into the patent law world.
Yes.
About 10 years ago or whatever. It was a Supreme Court decision that came down, and it really messed up a lot of it. It literally just stopped software patents in their tracks.
Yes.
And so I understand that from an inventor's point of view, it can be really frustrating to run into those sorts of roadblocks. But the law changes every day. The patent stuff changes every day. There's court rulings. There's the Supreme Court. It's a very difficult landscape to navigate, and some people have come up with kind of tricks to get around those issues with the software stuff, and some of them are just absolutely ridiculous. There's unfortunately patent applications that had to be abandoned, because they didn't say, simple words that just, don't make any sense in terms of the, patentability of the invention, but those words need to be in there in order to kind of weasel your way around some decision that came down from a court or whatever. So that's been a thorn in the side of patent lawyers for a long time. And I've beat my head against the wall many, many times trying to get software type patents approved. What I usually do is actually I'm working with a guy right now. I was actually just before this meeting. What I usually do is instead of patenting it as software, I usually try and patent it as a method or a process. So, you would break it down and you would say, let's try and think of an example, like a method of performing a transaction, where you've got one device and it's, sending some information to another device. That device sends some information back. That data is manipulated somehow, and then a result is displayed to somebody. So that's what you do, is you break it down into a method. What's actually happening? How's it going? And who's doing what? You just put it in terms of verbs. You're calculating, you're determining, you're sending, receiving, that sort of thing.
That's an interesting approach. I hadn't heard too much about that. Yes. So and Versa had another question. What feeling about keep filing patents just to be able to tell investors you have a patent pending?
Well, I mean, you're not lying. So.
Yes. So I think go ahead.
I was just going to say that actually brings up a good point. That it's a good point just in business in general, patents, law, everything is, whatever you do, you want to make sure that you're being truthful. If you start lying here and there, or even fudging the truth, that could come back around to bite you. So just don't do it. I've had to tell clients, unfortunately, that I can't get them a patent because they've disclosed their invention too long ago, and they've passed the window to file a patent. In the United States, that window is 1 year. So you got when you publicly disclose or publicly use, there's a bunch of different things that can happen. When you do these things, it starts that timer. So you have 1 year from the date. If you publish it, post a picture of it on your Facebook or whatever it is that you do, you've got 1 year. That timer starts running, and if you miss that And if you miss that deadline, then you're barred from ever being able to patent it. Why? Because the patent office wants you to disclose your invention as soon as possible. They don't want you to sit on it and wait around. So it's a harsh penalty because they really want to force people to go to the patent office soon. And that's why I said in that very first slide that you want to get to the patent office as soon as possible. When you got an idea, go to somebody. But yeah, like I said, sometimes clients are like, we're really bummed out that they missed that window. And they're like, yeah, well, what, but nobody knows about this, or, I never told anybody about this. It's like, listen, my reputation's on the line too. If I file this, I'm not doing it. So, I'm not, you're going to have to sign a piece of paper that says, that says to the contrary. And, I'm not going to take part in you lying. So,
Yeah.
I just can't ethically do that. I could get in trouble. I could get, disbarred for doing stuff like that.
I've heard a lot of attorneys talk with patent attorneys, and you're only the second one that, emphasized that point. And I definitely admire you for doing that, because, average person say, well, just they won't understand that. But I'm glad you explained it, that way. And so but like in Vercel's case, the lawyer said he needed a software patent, but then when they did the search, it was, I guess, potentially would infringe in too many patents that were already out, claims that were already out there in patents.
Yeah. So, I guess a couple points that I may have should have covered, but didn't in this thing, was a couple of the hurdles that you have to get over when you want to get a patent. The first one, the easiest one, is that the patent has to be for something useful. Mm-hmm. That's a real easy hurdle to get over. So useful, pretty much everything's come up as useful. Then it has to be novel. And novel, just in terms of the patent office, means that what you're trying to patent hasn't been described in any other single publication out there.
Okay.
So the patent office is gonna look at everything they can find. I mean, they're gonna jump on Google and they're gonna look at every research paper, every Facebook post, anything that's out there, YouTube videos. I've had all sorts of stuff, cited against me from the patent office, but mostly it's patents, because it's real easy for them to search for patents in that same technology area. So if you don't meet that novelty criteria, you're kind of sunk. The hardest one, the next one after that, is what's called obviousness. And obviousness means that what you're trying to patent has not been described in a combination of documents to where it would be obvious to a person at the time of the invention. So there's a couple little parts to that, but mainly it's the patent office is allowed to use multiple documents, not just one. It can pull a couple things together. It can say, well, yeah, here's part of what you've invented in this thing. Here's part of what you've invented in this other thing. If I can put these two together, and it's pretty obvious to me that that when I put these two things together that are in the same technology area, I've got your invention. So we're going to deny your application based on that. So that can be a tough one to overcome. And there's a lot of subjectiveness about whether or not, it's that rejection's proper. It's all, at the end of the day, you've got one opinion. The patent office person's got another opinion. You could get a different patent examiner and they might feel completely differently.
Gotcha.
So
gotcha.
It's not in. That's why it's such a difficult thing to answer. Can I get a patent on this? How long is it going to take? How much money? Depends on what side of the bed the examiner got up on that day.
Yeah, it's definitely, I believe it's a chat. And on a slightly different subject, I tried to do a trademark once on my own, which probably was a mistake. It didn't get approved. So it was the term was Solodex. I was working on a mobile application, and Solodex is something that's been around the idea has been around a while, but there was and it was, kind of to describe for a mobile application like a Rolodex, Solodex, but they denied it because there was a Facebook application, a mobile application that the name wasn't even close to I can't remember what the actual term was, but they denied it just based on that. It was a similar term, it's had maybe the same syllables or something, or I don't know what it was. But I thought that was kind of interesting, and I should have used an attorney. I probably would have had some more success with that.
There may have been some ways that an attorney could have looked at it and maybe argued or done something to get around it. Trademarks a little bit more straightforward than patents when it comes to that stuff. As a real quick 30-second good point, whenever you come up with a name for your business or a name for your product, do a search, make sure no one else is using it. Don't spend a bunch of money talking about a product that you're going to have to stop talking about and change the name of it at the last second when you find out somebody else has already named that.
I'm so glad you mentioned that, because that definitely is one of the number one things you need to do before you come up with a name for your software product or your company is, because Google search it, and then there's if you really want to search on the trademark website, it's called TEAS, TEAS, but you can just type trademark, trademark search, something like that, and you should be able to find that thing and just type in your word in the window there, and you can kind of see if there's anything similar to it. But I want to stress that shouldn't take the place of a trademark attorney's opinion of whether or not that's trademarkable, because I've had people say, oh yeah, I got this great name, and I looked at it and nobody else is doing it. Okay, fine. And they tell me the name and I file the trademark application, and then a couple months later the trademark office rejects it because there's another company that's got it's got almost the same name. It just doesn't have the S on the end, and his says company and theirs just says Inc. or something like that. And it's not exactly the same, but the trademark office is like, that's not a big enough distinction to be trademarkable, so we're rejecting your application. So it was really a bummer for that guy, because he was doing a clothing company, and he'd already put an order in for hundreds of pieces of clothing with that trademark on them, and I don't know, but that was the gamble that he took when he skipped paying whatever few $100s it would have cost, or even just watching a couple YouTube videos and figuring out how to search the trademark himself. So it's a minefield. So put experts in your corner so you don't step on a mine. I think you mentioned another thing that I want to emphasize a little bit is the fact that some founders they don't want to talk about their idea or because they don't have a patent on it, and so how like they don't want to pitch their idea because they don't think their idea is protected. What's your feeling on that? So they got you want to participate in the startup ecosystem and start building your product or whatever, but so like they're thinking, I'm trying to think of how to say this. So I guess based on what you said, if they haven't found a patent, and they're actually telling what their idea is that they're going to file a patent on, but typically to me the patent stuff is actually just the intellectual property that you're using your idea. When you pitch a startup, you don't you're not necessarily pitching the IP that you have in some cases. I guess I'm trying to figure out what the distinction is.
So one of the things that you might want to be careful about is, if you're given a pitch, if you're talking to somebody about your invention, are you giving away the key to how it works, right? I can talk about a product and what great benefits it has and what it does and how cool it is without telling you anything about the technology or how it's manufactured, how the app works, what process I'm using. That's, you can keep all that stuff secret. And I would recommend that you do that. Once you file the patent application, then you're a little bit more free to talk about stuff.
Yeah.
In terms of being concerned about stuff. So when you file a patent application at the patent office, you do sign a piece of paper that certifies that you are the inventor of it. So you're not legally allowed to just take somebody else's idea and go run to the patent office and file the patent application. Although, that may still be a minefield that you have to navigate if that would happen to you. But like I said, you can still talk about your idea and things like that. And if people want to have more in-depth discussion about how it works, or if you're going to a manufacturer to build something, non-disclosure agreement, NDA.
Yes. And I think that's really the point. And so I think when you have an idea for a product or service and you're pitching it, you're actually more pitching the problem you're solving and how your product solves that problem, not the technical underlying technology, like you said, that's driving. And I think that's a mistake people make, is they want to keep telling you about the technology instead of about the problem that your product or service solves.
Yeah, I actually put together a pitch as part of the G Alpha program, and I pitched a product that I had an idea for, and went through and talked about all kind of cool stuff about this product, and didn't talk at all about exactly what the technology was that made it work. I just said, this is what it is and this is what it does, but I didn't say how it does it.
Yeah, that's exactly right. And so, and the reason why I kind of bring that up is founders tend to make a lot of different excuses why they don't participate in the ecosystem, and they're afraid somebody's going to steal something, but the innovation type thing, in the ecosystem, where the ecosystem work, if people don't know what problem you're trying to solve, and it's hard to get help when you don't get an ecosystem and let people know what you're working on.
One thing that I want to stress to people is that, nobody has the same idea that you've got. Nobody has the same passion for that idea that you've got. And most everybody else, especially in an entrepreneur networking event, they're going to have ideas of their own that they're passionate about, that they're working on.
Yes.
I hear people talk about ideas all the time, and I'm like, cool, that's a great idea. And that's the last I ever think about it. I'm not scheming how I can steal somebody else's idea. I'm just like, oh man, that's a really cool idea. Like, I hope that works out for them. I hope they do really well with that. Meanwhile, I'm going to go back over here to this thing that I'm all about and I'm passionate for. Now, is it possible somebody could steal your idea, if you network and talk to them about it? Yeah, I mean, it's possible. But, at the end of the day, ideas are cheap. I mean, I could sit here in an afternoon and come up with a dozen different ideas for new products or types of businesses or something like that. But it takes a lot of hard work and time to turn that idea into a profitable business. Like 1% inspiration, 99% perspiration.
Right. And so, like, what I've learned participating in the ecosystem is the people funding people, they look at your team and your ability to execute on your idea. You can have the greatest idea in the world, but if you don't have the team to execute it on it, then your idea is worthless. So I always tell people your idea is worth zero when you validated and got potential customers willing to pay for a product or service that you're building based on your idea. That's when it starts to get a little value there. Yeah.
Yep.
So any parting comments before you? I really appreciate you going through it. It definitely brought a lot of thoughts into my mind, and Vercel says he's probably gonna give you a call. I noticed that comment in there. And so any parting advice, ideas, thought, main points you want to hit before we sign off here?
Just that, when it comes to patent stuff, I mean, keep it quiet until you talk to somebody. If you need to talk to somebody about stuff, Non-disclosure agreements are great. It's really, really about, there's a few different things. It's about the public disclosures, public announcements, use in public too. If you're out driving around on the streets using your invention and something in your car, that can be something that starts that 1 year clock. So again, going back to that slide, if you've got an idea, never hurts to reach out to a patent attorney and talk to him and just say, hey, what, should I talk to people about this? What can and what can't I do? You never know what, the laws can change at any time. So always just talk to somebody and get the most recent advice on your situation.
Okay, great. And I have one last question this is from an ecosystem. We talked about it a little bit. You mentioned you moved here to Pensacola and you sought out the ecosystem. What made you think to do that, or was it because what you had saw over in Austin, Texas, or what kind of made you look to see what was going
on? Just being an entrepreneur and being in the entrepreneur system is just something that's always been just something that I've identified with,
Okay.
So, some people, it's just when you see something, when you see a thing, you're just like, that's me right there. That's my personality. And
Yeah.
So when I came here, I knew that it was an opportunity to reach out and start meeting people. And so I thought, worst thing that happens is I, go through this thing and I don't like it and I go and try something else.
Yeah. And so I think I met you, I think whether that's 1 million cups or whether the entrepreneur ecosystem working group meeting, I can't remember.
Yeah, one of those. I don't think it was 1 million cups. I don't think I've been on one of those yet. But
yeah, okay, gotcha. Okay, so you found out that there is an ecosystem working group here, and got connected, into that, and you discovered the G Beta program. What else have you discovered that's actually here?
There's Entrecon, which is coming up here.
Yeah. Okay.
Fall. I really, honestly, what I did was I just jumped on and I found the spring and and I started sending emails. I just sent an email to because it was closed down at the time. They hadn't even opened yet when I moved here.
Gotcha.
I went there and I looked through the glass and it was all dark. There was nobody there. And, because that's just my personality. I was just going to go in and shake hands and say hi and just say, what do you got?
Fantastic. Well, I like that attitude. A lot of people think they need an invitation to go somewhere and check something out. And, you got to be curious, and, and that curiosity is what gets you connected, and you learn stuff just by being curious and not being afraid to just reach out there. Yeah, so that's great. So we thanks again for coming on with us tonight, and we do this every Thursday at 6 networking, and at 7 we have some guests, and we're gonna just want to let everybody know we haven't forgot about the pitch competition. We'll get a schedule and we'll announce it next Thursday, the date that we're going to do it, and we'll announce the date. We'll open up applications, and so we'll do it in time for you to get some money to kind of start your business before the end of the year or whatever. You get some cash in your pocket, and we're going to keep on working to get as many resources here in the ecosystem to help folks. And I'm even thinking about we have some Azure credits with the nonprofit, and I'm thinking about actually even installing some open source software for no code applications, and so people that we work with, they can actually use those applications for free to kind of get their idea up and running. So we're excited, and we're going to keep on, making the ecosystem better here and keep sharing opportunities so people can, turn their idea into an MVP, get, connected to resources to help them grow their business. Thanks a lot, Daniel. Look forward to seeing you soon. You take care. Appreciate it. opportunity to chat with you.
You're welcome. Thanks for inviting me. Good to talk with you guys.
Okay. All right. Bye-bye, everyone. We'll see you all next Thursday.